My name is Mark Krause. I'm an associate attorney with Copenbarger Copenbarger in the estate planning department. I do want to thank you all very much for joining us today for a webinar that we've entitled Leave a Legacy, Not a Lawsuit. Now here is some good old legalese for you. This is just some CYA stuff that basically says this information is provided for educational purposes only and should not be considered legal, accounting, or tax advice. The reason for this kind of a disclaimer is obviously because I can't give you narrowly tailored advice that's specific to your situation through a webinar. For that, we need to actually have a meeting. An attorney-client, relationship needs to develop in order for me to give you real, genuine legal advice. So this is just genuine educational stuff. But if things come up, if questions come up in your mind, please use this opportunity to schedule an appointment with us, and I can give you actual legal advice. There's a snapshot of our officers and attorneys. So we have 12 full-time attorneys with the firm, including, across multiple departments. I'm in the estate planning department, as I mentioned. We also have an estate administration department. We have a litigation department, which obviously is relevant to this conversation, which hopefully you'll never need, but obviously we're here to sort of discuss that sort of an issue. And we have a department that's kind of a hodgepodge that we call BTAP, and that stands for Business, Tax, and Advanced Planning. This is a picture of our lovely staff. We have a large and diverse staff that really makes us attorneys look good and helps us a lot every day that we really rely on. We have 8 different locations for your convenience all across Northern and Southern California. And of course, if for any reason that doesn't work with you at some point, we can also meet with you through Zoom or even by phone if necessary. So today we're going to be talking about estate litigation, how to establish protection for yourself. We're going to talk about family disputes, something I've been involved in quite a bit, common oversights, and just in general, some strategies for avoiding litigation. Estate litigation, the basics. What is estate litigation? Well, litigation is when you have a legal dispute and you need to take it to court to get that dispute resolved. Any sort of dispute that you need to bring before the court to get a resolution, in general, that's what we call litigation. The other half of that is estate. What is an estate? Your estate is basically everything you own, all your assets and liabilities and assets when you pass away. That'll make up your estate. So putting them together, estate litigation means litigating over all the stuff you leave behind after you die. That's estate litigation. As a tiny bit of background on me, before Copenbarger poached me from the firm I was at a couple years ago, I had spent some years doing primarily estate litigation. So I have litigated all sorts of cases involving probates, trust disputes, conservatorships, and any sort of thing that could be taken care of in probate court. So obviously, estate litigation is going to happen after somebody either loses capacity or passes away. Those are capacity issues and death issues are usually the things that wind up in probate court. It can involve wills, trusts, inheritance disputes. It can involve conservatorship issues, if you know what that is. It can involve accusations regarding someone's care or finances. So it may be the case that somebody's acting in a fiduciary capacity as a trustee or under a power of attorney, and they may be taking advantage of the person they're supposed to be taking care of. It may be the case that they're stealing money from them. It could be the case that somebody, after somebody has passed away, is acting as trustee or an administrator of an estate, and they're skimming money from all the beneficiaries. There's all sorts of disputes that can arise from these sorts of things. It can involve challenging the validity of documents. Really, really common cause of action in probate court when we're talking about the validity of documents is something called undue influence. Undue influence is a really common thing where you're basically not exactly alleging a lack of capacity, but you're suggesting, because lack of capacity can be very hard to prove, because capacity is the kind of thing that ebbs and flows over time. So even if somebody's been diagnosed with dementia, that is not a knockdown, drag-out argument that shows that they lack the capacity to enter into any sort of contracts or to sign any legal documents in the future. So capacity is a moving target. So for that reason, a lot of capacity-related disputes kind of wind up under the purview of undue influence, which is really just suggesting that the person or alleging that the person was vulnerable in a certain way. They were vulnerable to the influence of another person, and essentially you're alleging that that person used that vulnerability to take advantage of them and sort of exert their will upon that person in an improper way. So that is a really, really common cause of action to invalidate trusts and trust amendments and wills and things like that, is undue influence. And usually tied up in that are allegations of financial elder abuse as well. Why is estate litigation becoming more common? Obviously, as somebody who's practiced in it, it feels very, very common to me. That doesn't necessarily mean that it's actually the majority of trusts and estate plans, certainly, that end up in disputes. In my experience, the vast majority do not end up in litigation, but when you're sort of in the trenches doing litigation, it can feel like all of them. However, it is becoming more common, and why? We talk about larger wealth transfers. I'm sure I don't need to tell anybody here that's on this webinar that houses in California have gotten a lot more expensive. And given that that's often the primary asset that people are trying to protect with their trust, as the value of those houses gets higher and higher, the likelihood that somebody might fight over those assets becomes greater. Also, as it becomes harder and harder for people to sort of scratch out a living in California and buy their own houses, getting that inheritance from mom or dad or even grandma and grandpa becomes more and more important to them and to their own financial planning in the future. So the stakes essentially are a lot higher now, a lot of times, than they used to be. There are more blended families. The more and more sort of divorce, remarriage, and even death and remarriage that happens, the more opportunity there are for people to sort of be in complicated family situations that make the fallout of somebody dying more complicated. And when that situation is more complicated, the likelihood that people could fight over something is heightened, because it may be the case that you're willing to sort of forbear certain things when you're talking about your biological brother or sister that you grew up with your whole life, that you spent, your entire life, loving and getting to know and being with. You may not show the same charity to some guy that just happens to be related to somebody that one of your parents married after you were already an adult. So it can really change the dynamics quite a bit. People living longer. This is a problem that people have with Social Security, for instance, now. When Social Security was originally sort of laid out, the age was 65 because that was basically the average life expectancy of people was 65. Now, obviously, that's put Social Security in trouble because that is no longer the average life expectancy. As the average life expectancy keeps increasing, the likelihood that people, and this is going to tie in with this last one, competency challenges, likelihood that they might lose competency as they get older, the instances of Alzheimer's and dementia as people are living longer get higher and higher. The likelihood that people have struggles trying to figure out how to pay for things as they age, and fill those gaps. All these things increase the sort of instances that could lead to estate litigation and all sorts of litigation that can wind up in probate court. More late life document changes. The longer you live, the more likelihood there is that you might come back, see me, and change your documents. And some of these amendments might ruffle some feathers amongst your beneficiaries. Whenever there are ruffled feathers and there's an amendment, there is an increased chance that someone might try to challenge that amendment. So all these are reasons why estate litigation is becoming more and more common. Establishing protection, keeping your plans aligned. How are we going to establish a plan that's going to try to protect you? So, basic rundown of the sort of documents that you're going to be talking about when we're talking about estate planning. Obviously, my favorite one, a living trust. Typically, a trust is going to be a living trust that is revocable. That means, what it means by a revocable living trust is that it's around for the duration of your life, and revocable means you can take it back. And what you can take back, you can also change. So a revocable living trust is a trust around for your lifetime that you can either cancel out in its entirety or just make changes to as long as you're still alive. There are also irrevocable trusts that come in various varieties. Irrevocable means you can't take it back, basically. And for the most part, although we usually build in some kinds of exceptions to this, for the most part, you can't change it. And so because you can't change it, irrevocable trusts are going to have more specialized uses. Like there are certain kinds of irrevocable life insurance trusts. There are irrevocable trusts related to Medi-Cal and certain kinds of planning there. And there's other uses, but usually irrevocable trusts are going to be a little more specified for really narrow situations. The typical kind of trust that you're going to have if you're doing normal estate planning is a revocable living trust. Wills, this is usually the most common one that people have heard about. A will is essentially there. It's like a trust, but the major disadvantage of a will is while it can appoint someone that we call an executor to be in charge of taking care of your estate and carrying out your wishes after you die, and the will can direct where your stuff goes after you die, wills have to typically go through probate court. Wills are not sufficient to keep your estate out of probate court. So that's usually the main impetus for people to create a trust as opposed to simply a will, because they want their people that are taking care of stuff after them, their backup trustees, to be able to take care of everything without any court involvement, because that court involvement is massively inconvenient, massively expensive, and causes a whole lot of delays. The typical probate, best case scenario, if you're not familiar with it, a typical probate, whether it's a will or not, is probably going to take at least a year and a half. And that's if nothing goes wrong. Sometimes probates can take a lot longer if something goes wrong. A pour over will, but ask what's that? That's the kind of will that goes along with the trust. So if you have a typical estate plan with a revocable living trust, the pour over will is essentially a contingency plan that says if something really important was accidentally left out of the trust, the pour over will appoints the same person who's your backup trustee as your executor and tells them to put it back in your trust. So a pour over will is only there as a contingency plan to make sure if you accidentally leave something really important out of the trust, that it eventually gets back in there. Durable powers of attorney. These are financial powers of attorney. They appoint somebody to essentially be able to step into your shoes and manage your finances and do certain miscellaneous other things, like if you had an ongoing lawsuit, they could step in and have settlement authority. If you were being audited by the IRS, they could step in your shoes and handle that. They can file tax returns for you. But in general, it's to sort of manage financial assets. That's what this kind of power of attorney is for. Advanced healthcare directive. You could also simply call this a healthcare power of attorney, but because I call the financial one a power of attorney, I find it's a little confusing. So I prefer to refer to this as an advanced healthcare directive. It's essentially a power of attorney that allows somebody to make healthcare decisions for you. So, in general, you're going to use a durable power of attorney, the financial one, to have somebody manage your finances when you can't do that yourself, when you're incapacitated. Healthcare directive is to appoint somebody when you're incapacitated in general to manage your healthcare decisions. If you're in a coma and there's a big decision to be made about how your treatment's going to move forward, radically different paths, this high risk way, this low risk way, but may not solve all the problems. A healthcare directive is what ensures that somebody can make those decisions for you when you can't make them for yourself. Nomination of guardian, very, very important, lesser talked about document. Usually it's provided as a sort of addendum to a will. Usually it's done in conjunction with a will. Nomination of guardian is to nominate somebody to take care and be the guardians of your minor children if both biological parents pass away. So if I were to go on a date night with my wife and we were both to get in a car accident and pass away, without a nomination of guardian, we would have no say in who gets to raise our kids after we die. So a nomination of guardian, if you have minor children or if you're grandparents and you're concerned about your kids that have minor children, you need to make sure that there is a nomination of guardian in place, because even if we're talking about avoiding litigation, even under the best of circumstances, I have really good in-laws and I have really great parents. I don't want to leave them in a position where they just have to guess who is going to be tasked with the primary responsibility of raising my kids when I pass away, because even really good people in that circumstance might find themselves in a sort of contentious situation that could lead to litigation. Special needs trusts. These are trust provisions specially designed for people that are collecting certain kinds of government benefits, if they have certain kinds of disabilities. And essentially, special needs planning involves trying to provide for special needs beneficiaries without doing something that's going to cut off or interfere with their ability to continue to collect government benefits. Really important if you have a child or a grandchild or someone in your life that is collecting government benefits due to a physical disability or something like autism or Down syndrome, very important to think about special needs planning. You need to make sure when you're drafting these documents, there's all sorts of decision makers that you appoint throughout these various documents. You need to make sure you name people that you trust. Don't just simply name somebody because they're the eldest child or because they think it's going to be owed to them. You need to make sure that you trust these people. These are fiduciary positions, meaning you're investing a ton of trust in these people to carry out your wishes and in some cases substitute your judgment to do what you would want them to do if you still had the ability to make your own decisions. Need to name people that are trustworthy and reliable that will carry out your wishes, and that will make sure you want to appoint somebody that's wise enough and cares about your wishes enough to try to keep everything out of court. Life changes. So when you're establishing protection, you got to be attentive to life changes. If you have an estate plan, that estate plan needs to evolve as your life evolves because all sorts of things could change. Your personal circumstances could change. You might originally create a trust when you're a single person. If you get married, that's an important detail to take into account in your planning. Your trust likely needs to evolve as the situation with your marriage evolves, as you have kids. Obviously, that's a humongous change. So if you do a trust before you get married and have kids, and then you never change it after you get married and have kids, you can see how that trust might not really work for you anymore. It might not really be carrying out your wishes anymore because it's reflective of a single person with no kids. Divorce, huge issue. If you've gotten divorced, you absolutely need to get rid of that old trust. Typically speaking, you need to get rid of that old trust and get a new single trust. Part of sort of disconnecting and unwinding the sort of joint life you had with your ex-spouse is to dissolve that trust and create new trusts, individual trusts for each person. So please, I don't know how you would get through a divorce and still have this happen, but if you still have a trust somehow with your ex-spouse, that's something that you need to get taken care of right away. Family changes. You might have, like me, you might have parents as part of your decision makers in your estate planning documents. What happens if one of those parents gets Alzheimer's? What happens if both of your folks die? What happens if at one point you were going to leave everything to your brothers and sisters, and then you unexpectedly later in life had a child or adopted a child? These are all things that are major, major life changes that you need to make sure are actually reflected in your estate plan, because what's going to matter in your estate plan is the words that are actually in the documents. Your secret intentions of your heart that you've developed for yourself don't matter when it comes to a court of law. Assets change over time. You might have started, I was talking to somebody the other day that had created a trust very early in their marriage when they were worth maybe a couple $1,000,000, and they haven't really revisited it in the last couple decades. And I asked them what their net worth was now, and they said, oh, about 35 million, I think. That's a totally different can of worms. That requires all sorts of different planning considerations than somebody whose estate is worth $2 million. So as your assets change over time, maybe you've accumulated additional properties. Maybe your net worth has drastically increased. Maybe your net worth has drastically decreased at some point due to various things. These are all reasons why we need to make sure your estate plan is evolving along with you. Your wishes may shift. You might decide you feel really differently about somebody who's a beneficiary. If somebody was going to receive something at one point, maybe a small specific gift, and they turn out to be a huge jerk later in life, well, that might be something to consider, even a charitable beneficiary. A lot of times I've had clients where charitable organizations and sort of church and parachurch organizations that they've supported for 25 or more years suddenly change their value structure. They appoint new leadership, the old leadership passes away, and all of a sudden you have an organization that really doesn't reflect your values anymore at all. If you were leaving them a significant gift in your estate planning, that's something you need to take account of and make sure that that evolves with your changing wishes, and laws continue to change. The California state legislature keeps marching on, as does federal law as well. So something you may not be aware of, if you came and did a trust in 1995, the federal estate tax exemption level was, I can't remember exactly, somewhere around 800,000 to 1.2 million, somewhere in that range. That is a really different situation than we have now, where the estate tax threshold is about $15 million. So your planning might look a lot different depending on that change in law. And there's all sorts of other changes in law that is, the task of your estate planning attorneys to keep up on. Medi-Cal rules change all the time. We've had massive changes and flip-flops in Medi-Cal over the last couple of years. You need to make sure that your estate plan evolves with the law. If there's some massive change in law, you need to make sure you have a conversation with your attorney about it to make sure that they can advise you on how that might affect or not affect your estate plan. Outdated plans increase dispute risks. If you have a plan, that you haven't touched in 20 years, there could be all sorts of situations like I've just talked about that have developed that your estate plan is not really geared towards the best way towards carrying out your wishes anymore. And if there's sort of conflicts, ambiguity, maybe one of your children decides that they know that one of these people you're giving a gift to, you now hate their guts, and they know that, even though you haven't changed it in your actual document. All these kind of things can lead to fighting, litigation, all sorts of issues. There could be unnecessary tax liabilities that you haven't accounted for because you haven't done proper planning. Like I said, with the person whose estate is now worth, 10x of what it was when they did their original planning. We need to be concerned about their estate tax liability. And there's all sorts of strategies we can pursue to minimize that or account for it. But we can only do that if they actually talk with us or another attorney that can actually do that planning for them. Family uncertainty, loved ones filling in gaps. Like I said, your loved ones that know you really well might understand your wishes now. But if you haven't encoded those wishes in your documents, having that sort of disconnect between those two things can easily create all sorts of ambiguities, infighting, and even litigation. Costly consequences. If you have a properly drafted revocable living trust that's going to account for all your property, it can be administered oftentimes in half or sometimes even less than half of what it would take in an actual probate situation. And it'll, trust me, be far, far cheaper typically than any sort of probate administration. And so that's oftentimes the main reason why you did a trust or why you're pursuing a trust, to keep things out of court, to keep things simple for your family that you're leaving behind or your loved ones, to make sure that they're not spending a huge chunk of your money on administration costs. If it ends up in litigation, that sort of wrecks that plan, right? So litigation costs are very, very expensive. Often people can't really even get the litigation to the end, and they end up having to settle because to fully litigate a trust sort of dispute, like an undue influence case, like I mentioned before, all the way from beginning to conclusion, oftentimes you might be looking at an ultimate six-figure attorney fee bill, or at least, tens and tens of thousands, several tens of thousands of dollars, if not a six-figure attorney fee bill. That could be a huge chunk of your estate. Plus, during that time, none of your wishes are being administered because it's locked up in court. So it's really, really important, and not to mention the human cost of it. I have seen tons and tons of relationships and families just absolutely gutted and ripped apart just because there's some sort of dispute over mom and dad's stuff when they pass away, or grandma and grandpa's stuff, or their aunt and uncle's stuff. I have seen it happen time and time again. When I talk about this stuff, sometimes I feel like I'm Ken Burns doing a Civil War documentary. I'm like, these things that brother against brother, friend and neighbor against friend and neighbor, it really is like that. It reminds me of the Civil War. It just, creates dividing lines that can really rip families apart and destroy them. And while it's not possible to 100% litigation proof your trust or your estate plan, there's a lot you can do to minimize the dangers of that. So it's really important to do so. Key moments in sort of the life of your estate plan. Obviously, first time planning. Maybe this is right after you got married. Maybe this is while you're still a single person, but you bought your first house. Maybe this is right after you have kids and you realize, oh, geez, I need to do something to plan for these people. Oftentimes, the foundation that you lay might keep you, especially if it's done right after you have children, which is really common. That estate plan might serve you for quite a while. You, in fact, might not even feel like you need to come back and see me for a while. Granted, there's changes in laws and other things. You probably shouldn't wait too long, but a lot of times it can serve you for a while. But I have tons and tons of clients where they've done it right after they had kids, and then they come back and see me when their kids are in their 30s because they realize, wow, things have changed massively. I need to shuffle the deck. Now my parents, who I appointed originally, or my brothers and sisters, are not the people I want in charge. Now I want my 30 and 40-year-old children in charge of everything. All sorts of things can change that time. So there's a first time to establish a clear foundation. As those massive changes happen, we need to update older plans. As you maybe, have children for the first time, as your children reach adulthood, as parents die, as you maybe move and switch careers, your financial life changes, maybe you have falling out with old friends, maybe you even have a religious change. Maybe you went to one church that you really wanted to support at one point, and something happened, God forbid that church community collapses due to some sort of issue, and you're a part of an entirely different community now, and you need to make sure that those changes are updated in your estate plan. Helping aging parents. This oftentimes is more of a concern with your parents' estate plan, but if you do have aging parents, you need to make sure that their estate plan stays updated as much as possible, and to the extent possible is geared to help provide for them in their old age. There might be things regarding Medi-Cal or other long-term sort of planning, financial planning issues that you really want to look at your folks' estate plan to the extent that they read you in. I understand sometimes, for instance, I have a grandfather who's 94. He won't let me look his estate plan or talk to him at all about it. Even though he's got a grandson in the business, he's very private. He doesn't want to have any sort of conversation about that with me. Nothing you can do about that. But if your parents want and are allowing you to step alongside them and help them as they age, we really want to make sure that their estate plan is geared towards getting them, I'd say to cross the finish line, but is really geared towards completing their life's journey. Estate settlement needs. So identifying overlooked issues, you really want to also, especially as you get closer sort of to passing away or closer to the end of life, or your folks do, and you're talking with them, you want to make sure that you do give some thought to how are the provisions in this going to be practically implemented? How is this actually going to work out in real time on the ground? Are there logistical things I need to take account of that I haven't taken account of? This is why we have an attorney-client relationship. This is why I generally am not a fan of sort of do-it-yourself options and going to somebody that's not a real attorney. You may or may not know this, but there are paralegals and financial planners and a cadre of other people that can do estate planning, but I wouldn't advise that because you really want to be talking with an attorney that can really advise you as to how these things will practically work out on the ground, someone that you can develop a relationship of trust with, that you can go back and forth and sort of stress test the trust and figure all these very nuanced issues out. Family disputes. This is, something I used to deal with every day. This was my bread and butter when I was primarily just doing trust and probate litigation every day rather than what I'm doing now, which is estate planning. So dispute triggers, good intentions misunderstood. This is going to also tie in with something a little bit lower where it says ambiguous language. The trust, we need it as much as possible to not be ambiguous. We need to make sure that the trust is very clear about who's in charge of whatever they're supposed to be in charge of, what the spheres of authority are. We need to make sure it's very clear about what your distribution provisions are, where your stuff's going after you pass away. If there are specific gifts, we need to make sure that those assets that are being specifically gifted are clearly identified. We need to make sure that the rule, if there's any sort of obligations tied in with those gifts, like I'll touch on this later, but let's say you're leaving somebody what we might call a life estate that technically is not the correct term, but you might hear attorneys call this a life estate, giving somebody a lifetime right to occupy your home after you pass away. For instance, you might not want to ultimately leave this house to this person, but you might want to give them a lifetime right to occupy before it then passes to your kids or other beneficiaries. You need to spell out the terms under which their occupancy continues to be okay, because it could be the case that, like, let's say you have a spouse that's a second or third marriage and your house is yours, but you want to at least it's not theirs, but you want to let them, if you die first, live in that house for the rest of their life. You might want to set some parameters on that. Are you comfortable with them continuing to live in that house if they get remarried? Usually not. So you need to lay out those parameters. You cannot leave things up to your backup trustee to just guess as to what your intentions are. We want things as clearly spelled out as possible to avoid any confusion. You want to also make sure that you're not saying, not that you necessarily would, but sometimes people tell people all sorts of different things and create different expectations about what's going to be in the trust. And then when the kids get the trust, it turns out it's something completely different. Don't do that. Don't create ambiguity where there doesn't need to be. Don't create confusion. You don't need to necessarily disclose what's in your estate planning documents to your beneficiaries before you die, although oftentimes, not always, but oftentimes it's a good idea. But even if you don't disclose anything to them, don't give them false or contrary expectations to what's actually in the documents. Missing documents. You got to make sure that you know where your documents are. Sometimes Especially this can happen if you go to a sort of like, one of those paralegal or do-it-yourself options or financial planner rather than a reputable law firm. They might not keep any record of your documents. They might just give you the originals, tell you to put them somewhere safe, and then let you go on your way. Something could happen. You could lose documents. If nobody has a backup of those documents, that's a real problem. It's a real problem. You got to make sure that there are contingency in place. One thing I'll say for us, and I would say any competent firm, we maintain documents. After we sign them, we scan them in, and we maintain sort of backup copies for our clients because we know things could happen. We also now we give our clients, in addition to their originals back after, we give them a flash drive with digital copies of all their documents. You don't want to sort of have all your eggs in one basket. If something happens to those documents and they're the only copy in the entire world, that's going to create a problem. Make sure your wishes are properly reflected. We already talked about ambiguous language. Make sure beneficiary designations are properly accounted for as well. Part of a proper estate plan often involves beneficiary designated accounts like IRAs, 401ks, 403bs, life insurance policies that cannot be titled necessarily in the name of the trust, but you can control where they go through beneficiary designations. So part of your planning needs to take account of beneficiary designated accounts and make sure that that aspect of your financial life is integrated with your overall planning. Make sure you've designated the beneficiaries that you actually want on those accounts. No administration after a passing. This is a huge, huge issue. I'll touch on this probably a little more later because I believe I'm going to get further into A/B trust. But if you're talking about a joint trust where there are two spouses, when the first spouse dies, there are things that need to be done. I would advise you if you've recently lost a spouse, certainly my heart goes out to you. It's a terrible thing. And certainly you don't want to think about going and talking to some attorney after something like that happens. But unfortunately, the reality is you need to. You need to go talk to an attorney to make sure you're taking care of things. Maybe you don't have to do it the minute your spouse passes, but you don't want to give it too much time because the law of entropy is one of the biggest obstacles I face as an attorney. The obstacle of just overcoming entropy and doing something is what often leads people to never do an estate plan, to die without any estate planning, and really create messes for their loved ones after they pass away. So don't let, certainly understandable if your spouse passes away, that your attorney is not your first call, but don't let it go on too long because weeks can turn into months, can turn into years, and then you might pass away and have never done the administrative work that needs to be done after that first spouse dies, and you could leave a real mess on the hands of your backup trustees and beneficiaries to take care of. So make sure that if all administrative work that needs to be done after the passing of the first spouse, make sure that gets done. And if you're talking to your parents who are in that sort of situation, try to make sure that they know that they need to go see an attorney to get that administrative work done if their spouse has passed away. Verbal promises conflict with documents. I talked about this. Do not, a lot of our clients are people that are literate with the Bible, as I would style myself to be. Bible says, let your yes be yes and your no be no. Don't double talk. Don't promise a bunch of people stuff that's not actually in your estate planning documents. Make sure that you either, if you feel the need to, you can always sort of plead the fifth, stay silent about what's in there. But if you talk about it, let your yes be yes and your no be no. Don't give people the wrong understanding. Family loan accounting. This is something that comes up somewhat regularly. If you give advances to children, you need to make sure that if you want that actually integrated into your estate plan, i.e. if you've given one of your kids $200,000 for a down payment on a house, and you want that deducted from their inheritance, this cannot just be an informal understanding between you, them, and the rest of the kids. This needs to be something that is integrated into your estate plan. And if you're going to have a moving target that says, well, you're going to pay me back and I'm going to have a little exhibit attached to my trust that shows how much you owe me, every given year as you pay more of it off. Typically, I don't like that situation because it leaves way too much, that ongoing accounting requirement leaves way too much ambiguity and exposure for problems. But if you're going to do something like that, you need to make sure that those documents are properly updated on a regular basis. You need to make sure that if you're going to engage in loaning stuff to your kids, you want it counted against their inheritance, You need to make sure your estate plan very clearly delineates that out, because that's a very common thing for people to fight about. It might be one child's recollection, hey, mom and dad loaned them $500,000, so that's to be deducted from their estate plan. Might be the case that child you loan money to has paid you back $300,000 of that. How is, the first kid complain about it going to know? You need to make sure there's no ambiguity and no opportunity, or at least the smallest opportunities possible to fight about those sorts of things. Common questions. Bank account decisions. This is a common question I ask clients. Why did you put your child as a joint owner on your bank account? There can be a good reason, but oftentimes this is done, in my opinion, without sufficiently thinking about the consequences. Times where it's okay. So understand, if you have put a child as a joint owner on any sort of checking or savings account with you, that means that you both completely own the account. Or if it's, two spouses and a child, the child completely owns the account with you and your spouse. If you die, and the only person left is that child owns 100% of that account by operation of law. Now, you might think that your trust somehow overrides that. Something we say all the time, the trust only controls for assets that are actually in the trust. If you are jointly on an account with your child, I can tell you right now that account is not in the trust. So you need to be very careful about that. What are some of the issues? One, that having that child suddenly own everything out in that account after you die might be directly contrary to your wishes. That can create all sorts of controversies. It can also create suggestions of undue influence. If I'm another child and I know what your wishes are and I've read your trust, and you have this account with $200,000 in it after you die, and suddenly I see that one of my siblings is on that account as a joint owner, and they suddenly get all of that, which seems to subvert your wishes, which is that everything goes equally, that can create a real suspicion of undue influence that can lead to litigation. So other issues, you as a joint owner with your child on that account, you take on your child's liability. If they get sued and they jointly own an asset with you, well, that asset's up for grabs if your child gets sued. If your child has to go through bankruptcy, your asset is up for grabs. Their liability attaches to your account or your asset. If they get a divorce, they own 100% of that asset along with you. So that puts, you're taking on a child's liability whenever you put them on as a joint owner of an account or of a house or any other asset. So that's something to be very careful about. Times where it's okay. Sometimes I will tell clients that if you want to leave one small account out of the trust and have a child, typically the person who's going to be your backup trustee, be a joint owner on that account for maybe immediate access to funds for funeral expenses and things like that, that can be okay as long as you've taken that into account of your overall planning. You understand the consequences of that, because there is a little bit of a lag time often where you have to wait for a death certificate for the backup trustee to suddenly take over and have control over all the trust finances. So sometimes there can be a reason to do it that's okay, but it's something to be very careful about. And please talk to your attorney about it before you just start adding people as joint owners on all sorts of accounts and assets. House distribution concerns. Why isn't the house shared equally? You want to think through those issues and make sure that they line up with your wishes. Maybe kids think that they're going to get an equal cut of the house. That's often not the case. I mean, and often we leave a lot of discretion to the trustee. We call this non-pro rata distribution. It means that even if they're going to get shares that are equal in value, they don't have to get shares that are equal in proportion to every single kind of asset. Maybe one kid is going to end up at the trustee's discretion getting $800,000 in cash assets, and maybe the other child's going to get an $800,000 condo. That's typically going to be okay unless you draft something specifically different, but think through those issues when you're doing your planning. Unequal inheritance perceptions. Why is this child getting more than that child? I will tell you, there is going to be a webinar soon, I think, by one of my colleagues, Victoria, that's going to be addressing issues related to unequal distribution and how you should specifically set up your distribution provisions. So please be on the lookout for that to get into more detail about this. But in general, equality and equity are sort of different, right? Sometimes the just thing, the best thing is not necessarily just to give all your kids an equal share in everything. Maybe one of those children is married to somebody that's worth $100 million. And maybe the other child had a spouse pass away and they're a single parent and they're struggling. Should you give those kids equal shares? Doesn't necessarily, I mean, I will never step into somebody else's situation, tell them exactly what the right answer is, but on the face of it, to me, I would say maybe that's not the right move to give those two kids equal shares because their life circumstances are completely different. So don't just assume that equal is always right. Equality and equity are totally different concepts. Justice and it is not always just giving everybody something equal. You need to think about how you want to care for your, loved ones after you pass away and take into account their real life circumstances. Family assumptions, just because somebody's the oldest doesn't mean they have any particular rights to anything. We don't live in some sort of medieval code where only the first son gets to inherit and everybody else has to go off to the Crusades to find their fortunes. Whatever those family assumptions are, make sure that, you understand that and they understand that what's in the actual estate planning documents controls over sort of informal assumptions about things. And you might want to disabuse if you know some of your kids have certain kind of presumptions about things. You might want to prick that bubble and disabuse them of that before you pass away so that they have a little time to accept what reality is. Because I will say it's not always the right move for everybody to fully disclose what's in their estate plan with their kids or their sort of beneficiaries before they pass away. But oftentimes it's a good idea because I will say, as someone who, again, has some experience doing a fair amount of litigation in this space, often it's the joint two things together of perceived inequality, inequity, injustice, coupled with surprise that is really the problem. You really don't want to have a surprise that you see as really unfair and unjust when you're going through the grieving process. So at the very least, even if it's something that they perceive as unfair, or they don't like it, if they've known about it for 10 years before you die, oftentimes there's a more mitigated likelihood of them initiating litigation over something like that. But a lot of the litigation cases I would deal with, it's something they find out only after mom and dad die, that what they thought was the case is drastically different than what the actual case is in the trust, and they think it's really unfair. So that starts to lead suspicions that maybe my sibling exerted undue influence to procure this unfair thing in there, and then that we're off to the races with litigation. Hidden costs. As I already kind of touched on, years of costly litigation. Some of these litigation cases, in order to go to trial, it might take 2 years to get ready to go to trial. There could be all sorts of evidentiary motions. Maybe it takes 3 years to get to trial. I will just say in general, if you're practicing in, LA or especially Orange County, if you're dealing with really any county in California, but Orange County is one of the toughest ones that I've litigated a lot in. The last time I was actually in court was a few months ago covering a hearing for somebody. This was normal probate calendar. It was in early April. The earliest continued hearing date they had for anybody was in October. So we're not talking about like a 1 month continuance. So anytime anything needs to happen or be addressed such that there needs to be a continuance, often you could be looking at, 5, if not 6 months of a continuance for every single thing. So these cases can drag on for years. During that time, no one's administering your estate, no one's carrying out your wishes, and these things are very expensive. Low-level attorney's fees for a litigation attorney, you're probably going to be looking at least about $450. If you've got the partner of the firm representing you, you could be looking at a lot more. Obviously, there are court costs and other legal fees like expert witness fees. If you're doing trust litigation, you might need a handwriting expert to show that somebody forged something. I've used handwriting experts multiple times, or document construction experts. So in addition to just those attorney's fees, you're paying filing fees with the courts. You might have expert witness fees, depositions, all sorts of things your attorneys have to do. And meanwhile, all these costs are coming off the top of your trust. Typically speaking, you're the trustee. If they're defending the trust, they're typically going to be using trust money to carry out all this litigation. And meanwhile, the trust is just going to get depleted. It's going to keep going down as these legal fees and legal costs accumulate. So we really want to make sure we avoid improperly funded trusts. What funding a trust means, you put your assets in your trust. And typically that means that your assets are titled in the name of your trust, the ones that are supposed to be. For a house, you need to make sure that title, if you have a real estate agent or me do a title report, we need to make sure that title is in your name as trustee of your trust. If it's not, the trust does not own that house is not in the trust. If you die in that condition, then it's going to cost at least some amount of time and money and court involvement to rectify it. If you meant for that house to be in your trust, really common scenario, you refinance. They tell you to take title out of the trust to complete the refinance, the mortgage lender. Then they say, don't worry, you can put it back in the trust when this transaction is completed. You forget to put it back in the trust, goes on 20 years, you pass away. That's going to involve court fees, attorney's fees, and a bunch of hassle in order to rectify that situation and put that asset back in the trust. So make sure title of your house is how it should be. Make sure that you're checking bank statements and property tax statements and all those things to make sure they align with your planning and that everything that's supposed to be in the trust is actually in the trust. Make sure you communicate clearly with everybody. Make sure that you don't create, like I've said, false understandings with people that conflict with your actual estate plan. Don't create unreasonable or false expectations, because the grieving process is just a mess for everybody. I'm sure everybody who's on here has lost somebody. And when you're going through that process, even small things can erupt into huge, earth-shattering, sometimes family-splitting disputes. You don't want to add to that the risk of these sorts of issues, these fissures in the family, by creating any ambiguity or poorly drafted estate planning, or by creating false impressions or expectations from anyone just verbally that conflict with your estate planning. Sometimes these bonds never recover. Like I said, sometimes I feel like Ken Burns, and I'm talking about said brother against brother. I've had cases where two brothers or two sisters, or sometimes I've had where it's like four kids and, two take sides against two. And oftentimes they take them to the grave. A lot of the time, they never recover or reconcile. And it can, often that fissure translates down to their kids. And you sort of have, a civil war, even to, abuse another analogy in American history, the Hatfields and the McCoys. You can create that within your own family through these issues, and they can last generations. Make sure your intentions are clear. Try to reduce ambiguity and uncertainty as much as possible. Try to work with your attorney to spot any potential ambiguity or issues as early as possible to make sure they're addressed. Address risks before you pass away, before you no longer have the ability to address those risks. And like I said, family and meetings, with other individuals, it's not always a good idea. There could be a reason why you really don't want to talk with everybody about what's in your estate plan, but a lot of the time, as a general piece of advice, like I said, it's often a good idea to disclose what's in that estate plan with people, even if they're not going to like it, well before you're going to pass away, so that at least, even if they're not happy, they're not surprised when they're going through the grieving process. So, common oversights. What are some common issues that people goof on, make mistakes that lead to sort of litigation, other issues winding up in court? Bank accounts. We already talked about putting a child on jointly to your bank account. You can do this, but be very careful about why you're doing. And in general, my general advice is don't do it. If you want a child to be able to help you out with regards to trust assets, we need to make that child a co-trustee with you. Don't simply take the account out of the trust necessarily and add them on as a joint owner of that account, because that's going to be radically different than giving them authority within the trust to help co-manage a trust asset with you. If we need to talk about the distinction between those two things, schedule an appointment. We'll go through it and explain the difference and why that's important. But oftentimes, if you want a child to be able to help you with your finances as you get older, make them a co-trustee. Don't just simply take all your assets out of the trust and make them a joint owner, because the consequences of those two things are wildly different. Real estate, Proposition 19. Proposition 19 radically affected the ability to pass on real property to your kids without having the property taxes reassessed. It used to be the case that any piece of real property, any house, investment property, land, what have you, you could pass on to your kids, you could transfer to your kids, and they could claim an exemption, a parent-to-child transfer, that would result in them not having to pay increased property taxes. Prop 19 has drastically pared that down so that it has to be the parent's primary residence for at least 2 years before the transfer, and the child has to take it as their primary residence. The child cannot take it as a rental. It can't be a rental for the parents. It has to be primary residence to primary residence. So you want to think about that when you're laying out who's going to get a house or who's going to get property in your trust. That's something to take into account. Does this child have the ability to absorb increased property taxes? That's something to take into account. Also, something to take into account is might have, who might be best positioned to actually take advantage of Prop 19, and which child or which beneficiary might actually realistically want the house and be willing to take it as their primary residence, such that they can take advantage of the property tax increase exemption. That's something to take account of. Often we want to do in that case what's called a right of first refusal, which gives, let's say, your children a defined order where they can take a bite at the apple to take the property as part of their inheritance. You can say child A has the first right of first refusal, and only if they don't want to take the house does it now go to child B, then child C, child D. It's not a good idea to simply say, as I actually have seen in a trust that led to sort of controversy. I don't know the current status of the case because it was somebody from church coming to me and talking to me about it. But basically, there were 4 siblings, and all the trust said is, I want the trustee to try to facilitate one of my kids getting the property if they want it. No pecking order, nothing to resolve any sort of dispute if multiple kids want it. And lo and behold, 2 of the decedent's daughters decided they both wanted the house, so we had a conflict to resolve. Right of first refusal in your trust can help avoid that. Make sure all your stocks and annuities and anything beneficiary designated is taken account for and properly accounted for in your planning. If they have beneficiary designations, make sure the beneficiary designations are how you want them to be, that your attorney knows about it, and that it's integrated into your overall estate plan. Should the trust be the beneficiary of some of these accounts? That's a good question. It depends on what's in your trust. Typically, a lot of times it's 6 one way, half dozen the other. But there can be a reason where I'm really going to strongly encourage you to do that, to make the trust the beneficiary on some of those accounts. And that's typically going to be if your kids or beneficiaries are going to inherit anything in the form of a sort of sub-trust under the trust. Like I won't get into it now, but if you know what generation skipping trust provisions are, we often call these just lifetime trusts. They're vehicles for your kids to receive their inheritance in the form of a lifetime protective trust rather than just in the normal way, or special needs trust. If you have a child or somebody in your life that you're giving something to in your trust that is going to have a special needs trust, the only way it's going to get into that special needs trust rather than going to them directly is if you name the trust as beneficiary. If you name a special needs beneficiary as a beneficiary on your IRA or your 401k, they're just going to get the cash directly to them, and that's probably going to screw up whatever government benefits that they were collecting. So if you want to make sure that you've set up a special needs trust, that it actually works the way it's supposed to, don't leave a special needs beneficiary as a beneficiary on your IRA, your 401k, or your life insurance policy. Name the trust as a beneficiary. Letters of instruction. This is an informal document. It's just like it sounds. You can leave a letter providing all sorts of instructions to clarify wishes, to clarify where assets are located, to clarify all sorts of intentions, to help transmit your values, to explain what was going on in your head while you were making this trust. Whatever you want it to be, the letter of instruction can kind of be. It's an informal sort of document that you can just put in the front of your trust binder just to cover as many issues as you want to try to help deal with the possibility of things not going smoothly, to ensure that things go as smoothly as possible with the administration and make sure that you're understood. Outdated documents, you got to update the documents. Like I said, there might be legal reasons to update them. There might be pragmatic reasons and practical reasons based off life changes. You got to make sure your documents sort of go track with the changes that are going on in your actual life. Beneficiaries, make sure we review those beneficiary designations regularly. Make sure that they change along with all the other documents that form a part of your estate plan. Co-trustees. Really common litigation issue, really common thing that winds up in court. Let's say you have two children, and you want them both to be the backup trustee to handle your estate after you and your spouse die. 2 heads are not necessarily better than 1 in this context. That you're creating a very large point of exposure for potential litigation, because when there are 2 co-trustees instead of 1 backup trustee that gets to make all the decisions, anytime they disagree with one another, we can grind the administration of the trust to a halt. And a lot of times the only way to resolve those disagreements is litigation. So I usually advise in general against having co-trustees, against having people act together to be your backup trustees to carry out your wishes when you die. I will say this at the very least, though, if you're going to have, children or somebody be co-trustees, you need to make sure that their relationship is as solid as can be and that they're absolutely on the same page. Because even in the best of circumstances, they can have disagreements that lead to litigation. So certainly I've had clients where I ask them, do these co-trustees that you want get along perfectly? And they say, oh no, they fight all the time. They have totally different value systems. They don't even like each other that much. Absolutely not. You cannot make people like that co-trustees. But in general, don't do it. It doesn't mean you can't do it, but in general, I'm advising you not to do it. And if they don't get along perfectly, absolutely don't do it. Sometimes we can have a tiebreaker provision. So that's something to think about if you're going to sort of go against my advice and appoint co-trustees. Anyways, sometimes what we can do is name a third person not to be an active co-trustee with the others, but just to be a tiebreaker to help avoid gridlock. It's still not as good as just having one person do it, because then you don't have to involve the tiebreaker. And what if the tiebreaker refuses to act? There could be issues, but sometimes that can at least help mitigate against the possibility of future litigation. Financial healthcare literacy. Make sure that you're appointing people as your decision makers that have a reasonable idea of what they're doing. So sometimes what this means is, let's say you have two kids, one's a nurse, one's a CPA. It might be a good idea to have the CPA be the decision maker on all your sort of financial things, like your trust and your financial power of attorney. And maybe you have the nurse child be number one after your spouse on your healthcare directive. These don't have to be the same people. As I said before, being the oldest does not mean that they have competency or that they're the most trustworthy or that they're the best person for the job. Appoint the best person for the job. If they have special qualifications, competencies, or the reverse side, incompetencies, areas of incompetency, take that into account when you're deciding who's going to be your backup trustee, who's going to be your attorney in fact in your power of attorney, who's going to be the attorney in fact in your healthcare directive. Make sure all your planning goals align. Make sure all these documents and sort of accounts and everything form a coherent plan with the same goals that all work together and going to work together seamlessly. Make sure that you're meeting with your attorney ever so often. Usually we say at least every 3 to 5 years to make sure that we're accounting for legal changes and so you can avoid unintended outcomes. Funding the trust, I touched on this. Make sure that the assets that are supposed to be in the trust are in the trust, because a trust can only protect what it actually owns. If you have an asset that's not in the trust, the rules of the trust don't apply to it. It's sort of like, think of a constitution. The Constitution of the United States of America only applies to the citizens of the United States of America. If there was some sort of thing that happened where there were no longer any citizens in the United States of America, then the Constitution would have no applicability. If you don't have any assets in your trust, then the rules of the trust don't apply to anything. So make sure what's supposed to be in your trust is in your trust. Check, like I've said earlier, title reports on a regular basis, a good idea every so often. Check your property tax statements to make sure that they have the name of the trust, or at least a TR after your name to indicate that your house is in the trust. Make sure that you look at account statements for bank accounts and things that are supposed to be in the trust. Make sure you check on your beneficiary designations for your IRAs and 401ks and make sure that's how, they're set up the way that you want them to be set up. Make sure that you don't overlook any of your assets. This is one of the reasons why we have a schedule of assets in the back of your trust, because we want to make it easy to remember what all do you have. So it makes it easier for you, makes it easier for your attorney, makes it easier for your backup trustee to know what the assets are. That's a reason also to not only give us an accurate list of your assets when we're creating the schedule of assets, but let's keep that list updated. One thing we can do now, if we've done, your trust or updated your estate plan the last couple of years, you probably know that what we can do now with that flash drive that we give you with your documents, we give you a Microsoft Word template with your schedules on it. So if necessary, you can update just those schedules of assets yourself, because it could be the case that you rolled over an IRA into some sort of other thing and you didn't update it in your schedule of assets. Could be that you sold a house and bought a new house. We want to make sure that the schedule of assets are updated. So please make sure you do that. Protection strategies. Like I said, you want to identify any sort of gaps. You want to make sure that there's a cohesive, comprehensive estate plan that covers all the situations and is aligned with your goals. Make sure that none of your documents conflict with one another. If you've disinherited somebody in your trust and they're a beneficiary on your IRA, you might want to resolve that. I mean, it could be the case that you just don't want to provide for them in the trust, do want to provide them for them with an IRA, but it could also be the case that you just forgot to update those beneficiary designations. Make sure that your plan, that there's nothing conflicting your plan, that all forms a cohesive whole. You want to preserve, a lot of times what we're trying to do here, like I said, is keep things out of court, make sure things are as easy as possible for your loved ones after you pass, avoid the kind of contentious, horrible conflicts that ambiguity and poor planning and poor drafting of documents can cause. So what we're really, what I tell people, what I'm really trying to ultimately accomplish and what I'm really selling is peace of mind. I'm trying to do the best I can to make sure that you've left behind the best chance for your family to handle things as painlessly as possible when you pass, to preserve their relationships, to not have your death be a cause of division amongst them. So we got to make sure that we're regularly looking at things and updating things and being intentional about how we set things up so we can actually accomplish those goals and actually effectively give you peace of mind. If you just did a trust with the financial planner 20 years ago and you never looked at it again, that's maybe it was cheap, but it shouldn't really give you peace of mind, and it probably doesn't. So how to avoid litigation. We've kind of touched on this, but here's some clauses that are specifically in our trust that aren't necessarily in everyone's trust. Competency determiner clause. This is something in our trust that's somewhat unique. A lot of trusts don't have it laid out like this. This is a clause that lays out how it would be determined that you're no longer capable of acting as your own trustee because you no longer have the mental capacity to sort of make your own financial decisions. What that requires for us, it says 2 doctors here, but this is just a common other way people sometimes have it done. Sometimes those competency clauses will just say 1 doctor's opinion or 2 doctors' opinions. We have a sort of balanced approach where we say it has to be 1 doctor's opinion, written opinion after evaluating the person saying they can't make their own financial decisions. That opinion has to be ratified by people that actually know you. We call those competency determiners. So it might be, if you have a spouse, it'll usually be your spouse, but we usually have backups. Maybe it's a tiered order of your kids, child A, if they can't do it, child B, child C, or maybe it's even a panel of your kids. You might say that if you have 3 kids, all 3 kids, adult children, have to agree with the doctor's opinion in order for it to actually take effect. But we like to sort of set things up that way so that you're not able to be declared incompetent willy-nilly. Disinheritance clause. You need to make sure that if you don't want to leave something to somebody and they would normally inherit something under your trust, you want to make sure you have an actual disinheritance clause. Simply omitting them is not good enough. Often they can make an argument that their omission was accidental, especially if they're a child or a spouse or something like that. So make sure if there's somebody you want to disinherit, that we actually have a properly drafted disinheritance clause. And don't do the thing where you just leave them $1. Do a disinheritance clause. Contest clause. This is something that's often in trust, but really important that they be properly drafted and that they be included every time you do an amendment. So the case that's mentioned there, Zandluter v. Mueller, it came out in 2023. That case law is still relatively new. Some attorneys aren't fully aware of it, but it can create an argument that can cut off the trustee from using trust money to defend the trust in a lawsuit. That's really, really important because a lot of times cases will just be decided by who has the money to pay for attorneys and who doesn't. And typically speaking, you want your backup trustee to be able to use trust money to pay the attorney's fees so that they're in the best position possible to defend your trust against somebody challenging it. If you don't, the contest clause, what it basically is a disincentive to litigation. What it says is that if somebody does a direct challenge to the trust, if they were going to inherit anything, they now stand to lose that. They can be fully disinherited for going to court and challenging the trust without probable cause, without a good, valid reason to challenge the trust or an amendment to the trust. But that contest clause has to be properly drafted, to ensure that the trustee can use trust money to defend against the trust, particularly where they are also a beneficiary, because it can be argued that they're really just defending their interest as a beneficiary and not as a trustee, and that can provide a reason to cut them off from using trust money. It also is very important that a properly drafted contest clause is included anytime you do an amendment. If the contest clause was just in the original trust and you do an amendment that doesn't reiterate the contest clause, that's not necessarily going to work, and it's going to leave that amendment vulnerable to challenge. Interpretation clause. This is something that's typically unique to our trust. And basically what it says is you're saying that you're empowering Copenbarger in the future to interpret your trust if there's ever a dispute about what the trust means. Very common thing that can end up in court. We call these petitions for instruction. If somebody says, I think the trust means this, somebody else says, I think the trust means this, they can have to go to court to resolve it. We have a clause that specifically says that the trustee is empowered to rely on our interpretation, to seek out our written interpretation if there is such a dispute. And it says legally that they can rely on that. So a lot of times that can help resolve disputes before they get to court, or if the person pushes it into court, it can provide a really clear, easy pathway to resolve it without having to go through some long-blown trial situation. Attorney authorization to disclose trust violations clause. This clause is something that is unique to us, that as a litigator, I think is very, very important. Basically, it's a limited exception to attorney-client privilege that says, because normally I'm bound by attorney-client privilege. If you've come in and created a trust and done estate planning with me, I can't talk to anybody in the world about what's in your estate plan unless you give me explicit authorization to do so. And that attorney-client privilege covers the entire firm, not just me as the individual attorney. But there can be circumstances where I would want to be able to tell someone, and you, if you were in your right mind, would want me to be able to tell somebody about something going on with your estate planning. And typically what that's going to be is if you're under undue influence. If you, let's say that you have, the common situation I usually say is, let's say your spouse has passed, you've got a touch of dementia, you've got an in-home caregiver that's with you a couple days a week, and they suddenly bring you into my office and say, hey, this person doesn't care about their kids anymore. They want to give everything to me. Who could have thunk it? Normally, attorney-client privilege would bar me from telling anybody about that if you didn't give me authorization to tell anybody. And if you're under the thumb of that caregiver, if you're under their undue influence, you're not going to give me authorization to go tell anybody else about it. And the likelihood is, if they're persistent enough, they will find somebody to draft that amendment for them. And then I will have to wait till somebody calls me as a witness later in court to be able to tell somebody about it. What this clause says is that if I need to step outside of attorney-client privilege specifically to protect the trust and protect you as the trust, as this sort of trust creator in that sort of a circumstance, it says that I can do so. And typically what that means is I'm going to call your backup trustee that you've named in the trust and say, hey, this person is engaging in financial elder abuse and trying to subvert the trust. We got to get in there and stop it. And I could potentially also contact other family members and adult protective services as well. So that can be a very, very important thing. That situation is not far-fetched that I described. It happens, unfortunately, very regularly. It happens all the time. Planning provisions, real estate. I've already touched on the right of first refusal. Very important. If you think more than one child might want to inherit your house or another property, put in a right of first refusal so that you mitigate the possibility that they could fight about it. Life estates. It's really not the proper terminology. Usually the way I would phrase it in the trust is a lifetime right to occupy a house. So again, there might be a relative or even a spouse that you don't want to give the house to, but you want to give them the right to use that house for their lifetime. Very important to with particularity, lay out all the conditions on which they get to continue to occupy the house. For instance, you might want to say if they get remarried or they cohabitate with somebody, you might not want that new partner in your house. So you can say, hey, they have to scoot if that happens. You want to specifically lay out who's responsible for property taxes. Is the trustee responsible? Is the person occupying the house? Who's responsible for maintenance and repairs? If there's still a mortgage on the property, who's responsible for paying the mortgage? You need to spell all that out. Another thing you might need to spell out is if you've allocated any of those financial responsibilities on the trustee, you really should have something in your trust that says, hey, trustee, make sure you hold money back. If you've made financial distributions to other beneficiaries, make sure you hold enough money back so that you can make sure you can cover those costs if and when they come due. You can't leave it up to the trustee, because what happens if the trustee is responsible for paying property taxes and they don't hold any money in reserve to pay the property taxes? Now you got a problem. Now we have to figure out who's going to pay. And if somebody pays, who's entitled to reimbursement from the trust, how that's going to be accomplished. You need to spell these things out with particularity and make sure you cover all your bases. Landlord-tenant provisions. If you've given someone a right to occupy the house, what are the conditions? And when does your trustee have a right to evict people? As I already said, taxes, mortgage responsibility. and make sure that the trustee knows if they're going to have to pay for stuff, make sure they know they need to keep enough money in reserve to account for those things they might have to continue to pay. AB provisions. I'm going to start. I know we're going a little long on time. I appreciate everybody that's sticking with me. It's a very long, complex topic. I'm going to try to hit some of the rest of the things a little quicker. AB trust provisions. This can be very important for the next bullet point, blended families, especially. An AB trust provision it limits the ability of the surviving spouse to make changes to the trust after the first spouse dies. And the way it does that is when the first spouse dies, the trust splits into an A trust and a B trust that are funded by half the community property and any separate property. For the deceased spouse, their sort of trust, which we usually call the decedent's trust, it becomes irrevocable, meaning the surviving spouse can't make any changes as to where the deceased spouse stuff goes. So if they get remarried, sometimes our founder Lloyd calls these anti-gigolo, anti-floozy provisions, because if that surviving spouse gets remarried and they want to give something to their new spouse or their new spouse's kids even, they can only do it with their half of the stuff. They can't change where the deceased spouse half of the stuff goes. So it can be really important if you think you might need that, especially if it's a second marriage and you guys have different kids and they're not the same kids. You might want to make sure your kids are protected against that sort of a thing by putting an AB trust in place. Really important for blended families, really important, in the cases of remarriage and other sorts of issues. Make sure you've done proper special needs planning, and make sure that you pick the right people for the job. And maybe you have a special needs trustee that's different than your general trustee, because maybe someone else is better suited to watch and account for the needs of that special needs child or grandchild. But just in general, make sure you have the right person for the right job and make sure you've thought through what that job entails to make a person good for that job. Caregiving children, there's all sorts of things we can put into place that instructs the trustee on how they're to provide for your children if you have minor children. It's not a one-size-fits-all thing. We need to have careful conversations with an attorney as to how you want your kids to be provided for, what ages you want them to be entitled to things. You can even decide whether or not, if you want your kids to go on vacation, whether or not the guardians of your children get to spend any money on their kids to make sure they can have equal experiences with your kids. There's all sorts of nuances there. You need to take into account difference in financial circumstances of your beneficiaries. Like I said, equal and equitable and just are not the same thing. Take into account what your actual goals are and what the circumstances are for your beneficiaries. Maybe even if they have radically different circumstances, your goal is to just give them an equal share from you. That's fine. But if your goal is that you want to just put your kids in the best position for your estate to benefit them and help them be successful, take into account those individual circumstances. Make sure that the successor trustees, if you have an order of backups, that they're who you want them to be. Make sure you update that properly and make sure that you just set things up so that the right person's in the right job and that the succession of the trustees is clear. We do have something in our trust that's something else that avoids common pitfalls. A common pitfall, if you have only one, say, backup trustee, and they develop, say, Alzheimer's, or they pass away before they're able to administer the trust, and you're no longer around to pick a backup, that creates a reason to have to go to court. Typically, we do have a clause now that's standard in our trust that basically says if all else fails, Copenbarger will step in, pick up a backup trustee so we can keep out of court. That's another thing that we've done, seeing all these situations emerge time and time again, that we've sort of done to help mitigate another issue that can lead you to go into court after you pass away. Amendment versus restatement. There's two different kinds of amendments, broad strokes you can do a trust. A partial amendment says I'm only changing this paragraph and this paragraph. Everything else is the same. A restatement says I'm rewriting the whole thing to soup to nuts. There can be important reasons to do one or the other, but one thing you should be aware of, when you pass away, there is a notice that the trustee has to give out to all your heirs and beneficiaries, and that means all the beneficiaries named in the trust, and then any legal heirs that for whatever reason might be disinherited in the trust. All of them are entitled to notice when you pass away and entitled to a copy of the trust. Whether you do an amendment or restatement can be really important, because sometimes if you do a restatement, you can actually change who's entitled to notice as opposed to a partial amendment. So reshuffling the deck in that way, doing a restatement, can change who's entitled to notice. That can be a really important nuance to sort of capture and account for. So make sure you take that into account and talk to an attorney about that. Business succession is another really important nuanced, knotty issue a lot of the time to figure out with your attorney. And just make sure you review your documents regularly. Make sure that everything's how you want it to be on a regular basis. If you did your trust 20 years ago and you haven't seen an attorney, please schedule an appointment with us and we can help talk through and I can give actually narrowly tailored advice to you that is real attorney advice, not just general advice that I'm giving, to my black computer screen right now. So in conclusion, mercifully, I've gotten you to the conclusion at this point. Some of you are saying, thank goodness, we're finally here. So what is this guy with a magnificent beard here to tell you about in conclusion? Review your estate plan to make sure that it reflects your wishes. Make sure you've updated everything. Make sure your life as your life evolves, your estate plan evolves with it, and that it evolves with the law as the law changes. Make sure that everything is clear. Make sure all your estate planning documents and sort of beneficiary designated accounts are aligned and form a cohesive plan. Make sure that you've thought about common touch points that can cause disputes, and that you've done your best to mitigate against those issues and protect your family as best as possible. And if it's a good idea to discuss with your family ahead of time, which it often is, make sure you do that and make sure that there aren't false impressions and false expectations and warranted assumptions that people are making that could blow up in the future. Why work with Copenbarger? We've been open since, the late 70s. We've served, tens of thousands of clients. We have 13 full-time attorneys, over 500 years of combined legal experience. Some of us have advanced tax degrees and other advanced degrees in areas of specialization. We have over 45 highly qualified support staff, like I said, that make us look great every day. And we have office locations all over Southern and Northern California for convenience, and we can always meet you where you're at with Zoom or by phone as well. So make sure if you're going to sign off, I'm going to actually stay on to answer questions. If you're going to sign off, please check the chat. We put a link in there for you to fill out a digital evaluation. That is very, very important to us. We take your feedback very, very seriously. We don't know what to do to improve or to change if you don't tell us. We want these things to be helpful to people. What I want to do is serve your needs as a potential client or as a client. And I can only do that if you help me, if you become a participant in that project and help me figure out what's working and what's not working. So whether you want to tell me I did a great job or whether you want to tell me I did a kind of great job, please actually honestly fill out that evaluation form. The link will be in the chat. And also, if any of this has stirred any sort of, question or concern that you think really needs to be dealt with by having an actual conversation, getting actual legal advice from an attorney, please schedule an appointment with me or with one of my colleagues here at Copenbarger, and we can talk you through these things and help get everything figured out and answer your questions and give you not just general advice, but specifically tailored legal advice. With that, I am going to go ahead and I thank very much all of you that have stuck with us. I know this went a little long, but it was a very, very big topic. Believe me, if I would have thought everyone would stick around for as long as I could talk about this, we'd be here for days and days and days. So I appreciate your patience. I'm going to start with the Q&A, answer as many questions as I can from there. And then if there's any in the chat, I will answer those as well. So it looks like when I'm looking at the Q&A that most people have asked their questions in the chat. So I'm going to turn over to the chat, but feel free if you have a question that comes up as you're hanging on the line with me. If you want to throw something in the Q&A tab as well, feel free to do so. I'm going to open up the chat and I'm going to see what questions I have. Although one did just pop up in the Q&A. I'm going to give them priority. How is my trust affected if we move to another state? Very good question. It depends on the state you move to be honest. It depends how your trust is drafted. In general, the big broad thing that I can say that hopefully will bring you some comfort if you are going to move to another state is because of the full faith and credit clause of the Constitution, every state recognizes every other state's trusts as legally valid. So broad strokes, if you move to another state, even if you don't do anything different with your estate plan, in general, everything should still work the way that it's supposed to. Having said that, there can sometimes be little nuances that need to be captured by somebody that's specialized and has an actual, license in that state. So for instance, Arizona and Florida are two common examples of this. They have their own specific homestead language that if you are transferring your homestead, if you have your homestead and all your homestead exemptions set up in California and you're switching that over to Arizona, or you're moving to Florida and switching that over to Florida, they need their own individualized specific language in your trust, um, so that you can claim all the homestead, privileges and exemptions, if that new house that you're getting is in the name of that trust. So that often means that you need like an Arizona attorney or a Florida attorney to meet with you and put a specific clause in your trust to make sure that that works. There can also be nuances about things like property taxes and other things, that I can't advise you necessarily about because I'm not an expert in all 50 states and all the, estate planning laws. I've never drafted an Alaskan trust and I've never really litigated about an Alaskan trust. So if you move to Alaska, it's a good idea. Your California trust will still be valid, but there may be some nuances that you need an Alaskan attorney to catch. So I always say, if you move to another state with our trust, it's a good idea to schedule at least a meeting, with an attorney barred in that state to make sure that there's no nuance, minutia or nuances that our trust as a California trust hasn't captured, but your California trust is still valid in general, across other states. It will still work. Next, do properties held in an LLC receive a step up in basis to a fair market value at the time of death? Not necessarily. So if you want to make sure so it depends. So in general, probably the reason you're asking, because you probably are aware that if you've done proper estate planning, and you have a trust and you're holding properties in a trust, by virtue of those properties going through your trust, they will receive that step up in basis, and wipe out capital gains taxes at the time of your death. If you're asking about how that works when the properties are also in an LLC, the way that we want to take advantage of that ability of the trust to sort of wipe out capital gains taxes, reshuffle the deck on capital gains taxes, is we want the LLC to be in the trust. So it's easy. If you have an LLC and you have multiple properties held in that LLC, all you need to do is make sure that we put the LLC as a whole in the trust, and then sort of by the transitive property, the rules of the trust will apply to all the properties owned by the LLC. And then in that way, all the properties in the LLC will receive the same step up in basis, when the people that created the trust pass away. So I think that was kind of what you were asking. Hopefully I answered that question in the way that you were looking for. For anybody that has multiple properties, one of the things I mentioned is we do have a department that, covers business issues. Big thing we deal with in the business sort of side of things is creating LLCs for people, advising people about LLCs, S corps, and other business entities for their rentals and businesses that they own. Doing ongoing yearly maintenance for those various corporate entities. So if you have any sort of questions or concerns about any of those issues, you can also schedule an appointment, with one of our business attorneys to help you handle that. And you can just let us know that that's needed, and we'll help you get that figured out. So, are there specific wording phrases that need to be included in the trust that prevent beneficiaries from suing the trust because they aren't getting the payout that they want? I kind of covered this. The main thing there is the contest clause. So, again, it only really works for the most part as a disincentive if the person was already receiving something, because basically what the contest clause is it says if you're gonna get something out of the trust, you stand to forfeit it in its entirety if you challenge the trust in court. So it doesn't work if you fully disinherited the person. If you've disinherited the person and they want to challenge the trust, they don't have any skin in the game to lose. That doesn't mean it's the wrong idea to disinherit people. Sometimes there's really good reasons to disinherit people, but sometimes it can be a strategic point to leave somebody that you're worried about a little something, just so that they'll have skin in the game, so that the contest clause can be used as a realistic threat against them. Like maybe we're talking about a trust estate that's worth, a few $1,000,000, and you only want to give this person a $10,000 gift, but $10,000 does mean something to them. And you want to at least give them that to say, hey, I've got this contest clause here that says if you challenge the trust in court, you're going to forfeit that $10,000. So that's typically what we're going to put in the trust that'll try to mitigate against the possibility of somebody suing the trust because they're not satisfied with what they're giving, is the contest clause. When your trust is quote unquote finished How often do you recommend a periodic review? I think I answered this, but I'm going to definitely answer it again because it's worth repeating. Typically about, I mean, there's no bright line rule, but every 3 to 5 years is a good metric. But if you're a client of ours, um, if there's really important changes in law, typically we're going to send out some email blasts to you about that. Or if you're a client of ours, it's a reason to go to, maybe every couple of years, go to one of our seminars or attend a webinar and make sure that, you're just advised on any changes of law that you might have missed through email blasts and things like that. But in general, every 3 to 5 years is probably a good metric. Big thing, if it's been a decade, that's too long. If it's been a decade or 2 decades, it's way too long. So this is a message from us about answering questions. Can I assign a specific real estate agent to sell the house? My family doesn't live in my area. Um, I would advise against that. Because there could be a lot of things. I mean, one, your trustee, if you assign a real estate agent, says the trustee has to work with that real estate agent. I think it's questionable whether or not that's going to be fully enforceable. And because the trustee is invested with a lot of fiduciary sort of responsibility and discretion, they get to use their judgment. And I don't think it's a good idea to hamstring them in that way. I think the better idea would be to just, if you do trust your person enough to make them your backup trustee. If you want them to use a real estate agent, I would just put it in like a letter of instruction. And that way it's not necessarily binding because you don't know what circumstances can emerge. For all you know, by putting that real estate agent in there, when the time comes you pass away, it could come about that, they defrauded somebody, or they did something bad, or that they've developed, a little bit of dementia or no longer really very good at selling real estate for that reason. Who knows what could happen in the future. I would just recommend instead of doing that if you really want your choice of real estate agent, to just advise your backup trustee about that and maybe put that in a letter of instruction that's not necessarily binding, but at least makes your wishes clear in that regard. Okay. Here's another. Your child is a minor and one of the parents passes away, and having to fill out forms on her behalf. Do you have anyone that can help with the affidavit forms? Um, it depends on what you're talking about. I'm not sure, um, because, well, I mean, typically speaking, if it depends what we're talking about, because if you're talking about a minor child that needs a legal guardian, if you've put a legal guardian in place and they're having to fill out some sort of forms relevant to, taking care of the financial interests of the child, if you've nominated a guardian and they are in fact the guardian of the child, if they need help figuring out some of those logistics, they can definitely schedule an appointment with us and we can give them our advice. It's hard for me to predict exactly what we're talking about. If what you mean by filling out affidavit forms, I'm not sure this is what you mean, it's probably not what you mean, but just because it falls under the word in the heading of affidavit. If you mean, like, say, for real estate, like when one spouse dies, typically we have to file an affidavit of death, either of a joint tenant or of a trustee, to clear title in the real estate. We absolutely can help with all that stuff. So it depends. It's a good idea, though, if that guardian, especially if they're just tasked in general with administering the deceased parent's estate, in general, we could probably help with a lot of that stuff. It's worth them, if they have any need or question about it, to come see us to see if it's something we can help with. Filling out an employer, maybe. I mean, I would say that that's not really primarily what we do, is filling out beneficiary designations for your employer, something like that. But if there's other work we're doing and you bring that in, we can give it a look at you and talk about it and try to see if we can help. Here's another question. We moved to another state and met with an estate attorney from that state who made some amendments to our trust originally drawn up with Copenbarger. Should we have Copenbarger be aware of the amendment? Yeah, I think that's a good idea. Thank you for letting me know about that. I would say you don't have to, but I would say it's probably a good idea, considering we maintain records of all of our clients' estate planning documents. I would say even if you update them with another firm, which totally understandable, that if you're in another state, you've had another attorney from that state look at it and make some state-specific sort of changes to that, totally appropriate. I would probably say you don't have to, but it's a good idea to send us the amendment so that we can make sure that we have a fully updated set of all your estate planning documents, just in case somebody contacts us. It's a good idea because you never know what could happen. Maybe that firm no longer exists when you pass away and somebody ends up looking to us and maybe you lose the original documents. As an attorney, I'm very risk averse, so I like to cover as many bases as possible. So I would say, yes, please go ahead and send us your updated copy of your trust in an email or something and ask us to save it in your file, and we can go ahead and do that. I will give it another second or two. I very much thank the people that have hung around with me so long. I really appreciate your time and attention. I'm sure there's lots and lots of things you could be doing with your day, and I really do feel privileged that you've chosen to spend some of it with me. I hope that this was helpful. I really do strive to serve our clients and our potential clients and actually give people valuable information because I've seen how all these things, like I've said, can go terribly wrong. And it's really important for me to try to help people avoid all the ways where things could go really awful and sideways after they pass away. So I'm very passionate about this topic, and I really appreciate everybody's time and attention. I will wait for just another second or two for any other questions to come in. And even if a question managed to trickle its way in after I sign off in a second, we'll probably have somebody still look into it, and maybe I can get back to you via email or something. But having said that, please, if you haven't, like I said before, please click on the link in the chat to get back to us and fill out that digital evaluation, give us your feedback. And please, if you think that this is something worth talking about, please go ahead and schedule an appointment with us. I would be very happy to look at your unique situation and give you specifically tailored legal advice. Okay, with that, I am going to sign off, but I will leave everything open for another couple minutes. And I really, again, thank you very much for all your time and attention, folks. I hope you have a good rest of your day. Thank you very much.